Welcome, everyone. Thank you for joining today's CEO Roundtable. We will begin shortly. In the meantime, we ask that you please introduce yourself in the chat with your name, organization, and where you're calling in from. A few technical aspects to review before we get started. If you have any technical difficulties, please use the chat or reach out to the council staff that are on this call. Automated live transcript is available at the bottom of your screen to select show subtitles or live transcript. As an FYI, this meeting is being recorded, so you'll have the opportunity to rewatch anything that you might have missed. So thank you again for joining us today for our CEO Roundtable. We're grateful that you've joined us for this important conversation. I will turn the conversation over to Jen, who will be stepping in as today's moderator. We want to acknowledge Christy, who's our typical moderator that is unfortunately not feeling well. So we're gonna kind of switch gears for Jen to step in. And we wanna thank our partner for these calls, CEONet. We appreciate their ongoing support and partnership. So with that, hand it over to you, Jen.
Thank you. I will do my best to live up to, I know, what Christy normally does. So I'm excited to be here with you all and get to talk about this issue that the council has been working on, and talk with my colleague, Ben McDearmon, who's our Director of Legal Services. And I know he's been having lots of conversations on this topic. So we're excited to get to hear from all of you. As I think many of you know, the Supreme Court ruled in June in a case, Students for Fair Admission versus Harvard and the University of North Carolina. And while that ruling was really directed towards education institutions, especially higher ed institutions and their admissions process, the ripple effects of the decision have really been a topic of conversation amongst philanthropy, but other sectors as well. And it's a very fluid and evolving situation right now. And we're seeing kind of the ramifications of that decision kind of throughout the news and throughout our sector. And so I'm looking forward to talking with Ben about what he's hearing and seeing, kind of what he sees as the direct impact of that decision on the sector, as well as those ripple effects that, as I said, we're starting to see. So I've got a few questions prepared, but I'm really hoping this is a roundtable in the truest sense. And so that individuals come off mute, ask questions, and we want to hear what you're hearing and thinking as well. So with that, I want to start by asking Ben to kind of set the stage for all of us and give us that background and context about what the Supreme Court said in their decision, and what it means for philanthropy.
All right, thank you, Jen. And glad to be here with everyone today. As Jen mentioned, I have been talking about this subject quite a bit lately, both with member organizations and at some other organizations' events, webinars and conferences. So it's something that I'm pretty accustomed to at this point. And I know it's really an issue that has been raising a lot of questions within the field. So I'm really glad that I can be a part of helping organizations think through how this might impact their work. Just to give a little bit of background, as I'm sure many of you are aware, the case, really two cases before the Supreme Court that was decided in late June of this year, held that the admissions programs at Harvard and at UNC, both of which included a consideration of race, so they were race-conscious admissions programs. The decision in a single ruling addressing both cases found that those programs both violated the law. And there are two different prongs of the law that the court needed to get to both of these institutions. So UNC as a state university is directly subject to the Equal Protection Clause of the 14th Amendment. And so the court held that UNC's program violated the 14th Amendment. Harvard, on the other hand, not a state institution. However, it does receive federal funding, federal grants for research, and certainly federal student aid. And so as an educational institution that receives federal funding, it is subject to Title VI of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, and national origin in any program or activity that receives federal financial assistance. And so these were really the two ways that the court went about it. In the decision, they said essentially the UNC's program violates the 14th Amendment's Equal Protection Clause. And then they had in a footnote sort of this conclusory statement that says, and because it was a violation of the 14th Amendment's Equal Protection Clause, the same issue is a violation in the case of Harvard under Title VI. So really showing that the same standard is being used when considering discrimination under either a Equal Protection Clause or a Title VI claim. And specifically what the court did was they didn't overturn the existing precedent directly. So the case that had been the precedent in use for about 20 years before this, the Grutter decision involving Michigan, they didn't say that case is overturned. So that established the framework for evaluating whether or not an admission program that considered race was or was not unconstitutional. But what they did was they rejected the idea that there are educational benefits that stem from having a diverse student body, and that is a compelling government interest that could justify the use of race, which was really a necessary element of that framework that was established in Grutter. So while they didn't explicitly overrule it, it does make it very difficult, if not impossible, following the court's decision to design, in all likelihood, an admissions program that considers race in a way that doesn't violate the law under this new framework that this court has established. Specifically, they said that the institution's diversity goals lacked sufficiently focused and measurable objectives that warranted the use of race. So they weren't narrowly tailored enough. That's a really important distinction for any of these, anything that uses race or another protected characteristic in making decisions. There needs to be this compelling government interest, and there needs to be real narrowly tailored means to achieve that interest. They also said there's no meaningful connection between the admissions process and the educational benefits of diversity, and that the racial categories that the universities use were too imprecise and either over broad or under inclusive. So they really took issue with the way that the universities were going about using race as a means to achieve this goal that they stated was a diverse student body, and in doing so rejected the idea that diversity by itself, and just claiming that the idea that if we have a diverse student body, that by itself produces educational benefits that are sufficiently compelling to justify the use of race, which would normally be prohibited. So that's how we got to where we are now. I'll say there was, leading up to the decision in the months before that, there was a lot of speculation as far as what might the impact be on philanthropy. There was definitely some concern within the field that there may be a decision that is much more broad, or language in the decision could apply beyond the scope of admissions alone. And so there were some people who initially celebrated that the ruling was actually very narrow. It was on the case before the court. They did not go beyond this, so they didn't address such topics as, in fact, the U.S. military academies. They even said in the decision that the U.S. government has said that there are reasons why the military academies should still be able to consider race when forming their classes, that get to the idea that the military academies have this separate role. It's not purely educational, but they're also educating future leaders of the military, and so they want to ensure that the leaders of that are diverse, and they represent the larger core of those bodies. And so they said, we acknowledge that the military academies are not a party to this. We're not ruling on them right now. They didn't address scholarships directly. Didn't address the use of race neutral factors that could serve as a proxy for race. That was another area where people were speculating beforehand how broad could the ruling be? Could it suggest that these race neutral factors might be immediately prohibited as a result of that decision? They said in the majority opinion, we're not considering that right now. We're not ruling on that. The parties here have agreed that this is not an issue before the court. Again, that doesn't mean that they're not going to take that up. There's another case that's making its way through the courts right now involving a similar issue. It's at a public magnet high school in Northern Virginia. So there's certainly something that the court will rule on. They just didn't do it in this particular case. Also didn't really directly rule on anything like DEI initiatives by employers, although certainly a lot of questions have come up around whether or not some of those are compliant with what the law already said under Title VII of the Civil Rights Act of 1964. So there's limited immediate direct impact on a lot of foundations and nonprofits, given the scope of the ruling. But there, I cautioned people to be at the outset who were saying, "Oh, this is actually not as bad as it could have been." The caution was, hey, this doesn't mean that this won't affect you. It just means that in the immediate aftermath of the ruling, there's probably nothing that you're doing in most cases with foundations that is directly impacted. But there's a framework that's certainly established by this case that activists who are seeking to remove race from a consideration in various facets of society, which we know there's a pretty well organized group doing just that. There's certainly a framework for them to use to attack different types of programs that go beyond the scope of this case.
Sorry, I had to find my unmute. Thank you for that, Ben. And just put in the chat, the council has a resource page that we are consistent or trying to update, as we can about the decision and walks through a lot of what Ben just did. And so if that's helpful for you, we've got that resource there, as well as resources that Ben and his team have put together that answer some questions that we've got around what the Supreme Court's decision may mean for the sector. And so, but we'll get into some of that today too, but want to have that resource available. So Ben, I know we have talked a lot about this, but you talked about kind of that subsequent, the subsequent cases that are coming because of the Supreme Court's decision. And one that you and I think, talk about daily is the one down in Georgia with Fearless Fund. For those on the call who aren't paying as close attention to this case as we are, can you talk a little bit about why this is something the council is really engaged on and what that case is about? Sure.
And yeah, if we don't talk about it daily, it feels like it, at least. But it's significant and one that we're following because this is a case that, on its face, and I think the way it's been reported in the media, people who don't follow it closely may have even missed this connection to the philanthropic sector and to nonprofit organizations, because it's reported widely as being a lawsuit against a venture capital firm, which it is on paper. They're suing Fearless Fund, which is a venture capital firm that invests in Black women-owned businesses. But one of the parties that is named as a defendant is a related 501c3 called Fearless Foundation. And the grant program that's being challenged is actually run through this foundation. So in fact, it's the first, as far as I have seen, and as far as I think anyone on our side is aware, the first legal challenge under a 1981 claim, which is to say the statute that prohibits discrimination on the basis of race in making or enforcing contracts. It's the first claim using that as the basis for the claim against a grant-making program at a 501c3 following the court's decision in June. So it specifically cites, and in fact, it's actually being brought by a group that's founded by the same man who was behind Students for Fair Admission. So it's part of the larger organized effort to go after programs that use race in some way in making decisions or deciding who is able to benefit from a particular program, and looking at ways to apply. Now, the court has decided in the Students for Fair Admissions case, it really relies on some of the same language and cites directly to that decision. So it's significant in that it is, even though it's not been widely reported as a case involving or against a 501c3, that is in fact what it is. And so at the heart of this case is whether or not a foundation can limit eligibility for some of its grant programs based on characteristics like race. And I'll say too that there are some facts in this case that probably aren't ideal, and people have asked, well, why did they go after this? It's not like this was a high-profile grant program to begin with. And I think the answer to that is it probably was one of the easier paths to take if you're looking to prove as a plaintiff that there is discrimination on the basis of race in the making or enforcing of a contract. You need to have certain elements that you can show. First of all, you have to show there is in fact a contract that exists, or an invitation to enter into a contract. And as many of you probably are aware, not all grant programs involve making contracts. Some grants that foundations make are pure gifts. They're made without the kind of strings attached that would render them enforceable as contracts under the law in that applicable jurisdiction. So it's not necessarily a guarantee that if you were to sue a foundation for what appears to be racially exclusive or racial preferences in a grant-making program, that you could even make the case it's a contract. In the case of the Fearless Fund case, they actually said on the terms and conditions on their website several times, read this carefully. You are entering into a contract. This represents a contract between us. So, in some respects, I guess they made it a little bit easier for the plaintiffs to say, well, there's one prong right there, and then the next thing they needed to show was that there's racial discrimination. They could show the eligibility criteria limit applicants who may apply for this grant program to Black women-owned businesses. So I think it was a situation where, given the facts involved, it was maybe an easier case for the plaintiffs to make, to say, we have, essentially they had in this group that sued them, several business owners who were anonymous in the filing, but they said, we meet every other criterion for eligibility except for the racial restriction. And so they were asking the court to find that the program as run was unlawfully discriminatory on the basis of race, and that they should reject that provision in the eligibility and open it up to their plaintiffs. And so they asked for the court to also grant a preliminary injunction saying you can't close this grant cycle, which was scheduled to close on September 30th, pending the decision in this case, because these plaintiffs will be harmed by not being eligible to apply. So that's where that case, that's how it started out. The district court actually held that there was not sufficient evidence that was shown on the part of the plaintiffs that they would prevail on the issue. They specifically cited a First Amendment argument that the Fearless Foundation rather's decision where to grant money is protected speech. It's a form of expressive conduct, which the Supreme Court has told us can be such decisions as where to or not give money, or for what purposes, as long as there's a clear viewpoint that's intended through that conduct of giving money, that's speech that's afforded First Amendment protections. So the district court was persuaded by that, and they said, we're not going to grant this preliminary injunction on the basis of that. The plaintiffs then appealed, and the 11th Circuit, a panel looked at that and said, we actually reject the First Amendment argument. We think that the defendants have not established that that is in fact protected speech. We think the plaintiffs stand a good chance of prevailing on the issues, and so we're going to go ahead. It was really the day that it would have closed. It was September 30th that the appellate court stepped in and said, we're going to grant the preliminary injunction. You can't close this grant cycle until this issue is decided. So that's where things stand now. The parties will be filing their briefs in the coming weeks, and we'll see how the 11th Circuit rules on that question. But again, it looks like a really important part of that will be this constitutional question. Is this decision to limit their grant making to Black women-owned businesses, in fact, expressive conduct to the extent that it's afforded First Amendment protections?
And Ben, I'll let you grab some water. A question in the chat. So, and I want to make sure I'm getting this right. Alex is asking if Fearless Foundation is a public charity or private foundation, and the Fearless Foundation is a public charity, correct?
I believe it is, yeah. And I see the question, is it even relevant? I don't think it is a relevant question. And the reason is, if the case that's being brought here is on a Section 1981 claim, and that statute makes no distinction based on the identity of the parties involved. It applies to private actors. So even if this were a case where they were, let's say there was a possibility that we're talking about a government actor versus a private actor, under Section 1981, that doesn't matter. Now, under a claim based on potentially the 14th Amendment or Title VI, then certainly the question of are you a government actor or are you federally funded would make a difference. But for a Section 1981 claim, the status and identity of the parties isn't significant there, because whether or not they're a private foundation, whether they're a public charity, the law would apply equally. So that, that's why it's important to understand, the impact of this, or the potential impact of this case does, have for 501c3 grant making, given that it is a case involving a 501c3's grant program.
Thank you for that. And I hope others will add more questions in the chat. Looking around this group, I know that you guys have lots of experience, but also I'm expecting a lot of people to come off mute and ask questions or share what they're hearing as well. Kind of shifting gears, Ben. I know one of the questions that we have gotten at the council a lot after the Supreme Court decision is really, does this impact scholarships that so many of our community foundations have? And you just did a webinar on this recently, but can you talk a little bit about if there is any impact on those programs at all?
Yeah, you're right, a common question. Really where things stand now, or what the best answer that we can give at the moment is, and again, a lot of this is really going to play out over the coming months and even years as some of these programs are challenged, because that's just honestly the way that with unresolved issues like this, it becomes a question for courts to work out. So the potential avenue, let's assume that we're talking about a community foundation scholarship program. It doesn't involve any federal funding. Whether or not that foundation has received some federal funds for a different program or not, that likely doesn't matter. And I should briefly say, for those who are wondering, if you received, for example, money that was you're regranting through your state or municipality through ARPA or some CARES Act dollars, that doesn't mean that your organization is treated as if it's federally funded for the purposes of Title VI across all of your activities. Generally, Title VI and the non-discrimination provisions of Title VI would apply to the specific federally funded activities and programs, but not to all of your activities. So if an organization is not broadly funded by federal dollars, or if it's not principally engaged in education, healthcare, housing, social services, or parks and recreation as its primary activities, so that's principally engaged in those activities, then just because, for example, you might fund in some of those areas, that's not enough to make you subject to Title VI across all of your activities just because you've received some federal funding for some program. So that's the typical answer that I give to people when they ask, does Title VI apply to us? So let's assume, you're running a scholarship program funded by private dollars that are donated by individuals or companies. So it's not subject to Title VI at a general level. Really, the avenue that somebody might be able to make a claim that against that program is likely this Section 1981, that this program represents a contract or an invitation to enter into a contract, and that the use of race in determining who receives it is a violation of Section 1981 because it's discriminating in the making or enforcing of a contract on the basis of race or ethnicity. So what it comes down to in this sense is that program actually a contractual agreement with the recipient? As with many grant programs, of course, it's possible for that grant to be a contract, but it's also very possible for it to include some limitations on how you're using the funds, but very few restrictions beyond that. There's no obligation to achieve some specific objective or to produce a particular report for the foundation or anything like that, that could render it to be appearing more like a gift. So for those that are truly gifts to the recipient, rather than appearing to be a contractual relationship that you're entering into, I think the answer is that generally somebody would have a difficult time making that claim under Section 1981. They're going to have to prove this is in fact a contract or an invitation to enter into a contract. So the fewer restrictions and requirements that are placed on recipients, it's likely, or rather less likely, that a court would find it to be a contract. There's unfortunately no bright line rule that says in these situations it's a contract, in these situations it's not, but the general rule is the fewer restrictions that are imposed on an award. So I've had questions about, if you have a renewable agreement for multiple years, is that sufficient? What objectives would they have to, can you make them reapply and say you're eligible to reapply, but you still have to go through the process of reapplying next year? You're not automatically entitled to a subsequent award by simply achieving certain GPA or other benchmarks. The other thing I'll point to, this question of, is race the eligibility, is that a criterion for eligibility at the outset, which is to say nobody else can apply, or is it merely one factor among several or many that are considered? And if it's merely one factor among many, I think that also provides a better potential defense against the Section 1981 claim. A plaintiff would have to show not only is there a contract or an invitation to enter into a contract that exists here, but also they would need to prove that race was the reason that they were denied. And so if race is not the sole determinant in whether or not they're eligible at the outset, I think they have a more difficult time proving that, because there are conceivably other reasons why someone else was chosen, not them. Somebody may have had more compelling essays, or better GPA or test scores, or whatever the criteria might be. So to the extent that race is one factor, not the sole factor in determining whether somebody can apply and is eligible in the first instance here, I think that could help too.
And in addition to just kind of the scholarship programs, I mean, we've had questions around, broadly support for initiatives that are in advancing diversity, equity, and inclusion. And I assume that the answer is very similar. If a foundation has grant programs that have that broader mission of advancing diversity, equity, inclusion, would have to go under Section 1981 and all those pieces. But is that correct?
Yeah, and I think this is a good time to raise this question and my typical answer to it, which is to say, I have a lot of people ask me, or one of the questions that, maybe it's not the only question they ask me, but one of the questions that comes up is, how do we avoid being sued? Or, we want to make sure our foundation doesn't get sued. And I always say, if that is the sole or primary focus, is avoiding being sued, you really need to have a conversation with your board and leadership to say, is that really what we're trying to do here? Is the primary objective to avoid a lawsuit, in which case really the only safe path forward is to retreat from doing this work? Or I think for a lot of organizations where the answer is we don't want to retreat fully from this work, the question really becomes more, how do we set ourselves up to, in the event we are sued, we have a solid understanding of what our risks are? Because really, I think the only way to truly avoid being sued in this climate, the way that we know things are, is to completely retreat, to stop openly working on these issues at all. And that's obviously not what a lot of organizations want to do, and rightly so. And our role at the council is really to help people understand, what's your level of risk? What are you comfortable with as far as potential litigation involving your organization and your activities? And certainly you can take steps to make sure that in the event that you are sued, you have a pretty solid defense that says, we believe this is different from what the law clearly prohibits. But at the same time, there's right now no foolproof way to avoid getting sued, except to just stop talking about racial equity work, unfortunately. And I'll also highlight too, a call I was on a few weeks ago with the executive director of the Lawyers Committee for Civil Rights. He was another speaker on this, and he raised a great point that I had not made to people before, but I've since incorporated this point. People, he's really pointing out, what is the actual risk, and thinking about it in that way. In most of these cases that are being brought, plaintiffs aren't seeking huge money damages. They're really, what their objective is, to get a court to step in and say, this program, you can't operate this program this way anymore. So while, of course, nobody wants to go through being sued and being a party to litigation and going through that, know at the end of the day that in all likelihood, a challenge to your program is going to seek to have the program stop, but it's probably not going to be seeking some significant amounts of money from the organization as compensation for perceived damages. So just know that as far as weighing risk, obviously at the end of the day, there is a bottom line question that comes into it involving what's our potential exposure here. And for most of these lawsuits, their goal is just to get the program to be shut down. And along those same lines, I will say for those organizations that are taking the approach of we're just going to stop doing this because somebody has suggested that we might get sued or somebody sent us a letter threatening us, I would say in some ways these activists are winning without even having to sue people. You're basically in those situations letting them off kind of easy. They don't have to actually take the steps of filing a lawsuit and proving that you're doing something wrong. I know that different organizations have different levels of risk tolerance, and our role is not to tell anybody what they should or shouldn't do, but I hope that we are able to give people a clear idea of what the risks are likely to be.
Thank you, Ben. And I think that, the other piece that we are really encouraging foundations to do is have those conversations with your board, with your staff, and even donors, of just having those active conversations. I think because what we saw, at least right after the Supreme Court decision was announced, is those who had been active in the conversation leading up to it kind of were ready for that, and there were many, though, within our sector who were not prepared for that. And that the surprise sometimes causes an overreaction versus having those conversations up front and really just being clear about what's the mission, what's the goal, all of that of the organization, and so that should hopefully we don't want anyone to get sued, but should something happen, you're prepared for that. There's a question from Shelley in the chat, Ben. If we see any tangents of this ruling extending to the donor side, especially as we think about anti-hate funding policies, and that's a question I haven't actually heard before. So I don't know if you've.
I haven't either. Yeah, Shelley, if you want, I would love to hear more about what you're thinking along that.
Well, we just passed an anti-hate funding policy 2 weeks ago at our board meeting, with help from the Council on Foundations, the Horizons Forum, some work we did with CF Leads and the Eli Initiative. So it's on the forefront of my mind, but we had a long conversation and actually did some hilarious role playing and stuff with our board about if we have to make that decision, how is that going to be perceived? And we have those things in place, but it just feels like, as I hear you talking, that these rulings could transfer over to that side as well. Just the idea of the donor can direct their money in their donor advised fund wherever they want to, and that we have no say over that, even though I sign the checks from my foundation. And I know we legally own that money, but I just wondered if that had come up in any discussions at the council yet.
It hasn't, and it's because I do think that the tax code is very clear about the legal ownership and control aspect. It would be hard for me to see a way that a donor could, given the framework that exists now for being able to make a tax deductible contribution to a donor advised fund while retaining that advisory privilege. I have a hard time seeing how somebody could make a legal claim that, essentially when they sign a document that says we acknowledge that the foundation has legal control over all grant recommendations are merely advisory, that they would somehow have a claim to make that could compel the foundation to grant to a particular grantee. Because here's the thing, the answer would be you as the individual donor are free to individually give to that organization, and nobody is taking that right away from you. But to the extent that you have contributed money to a donor advised fund held at this community foundation, you have already given up control over those assets subject to the policies that we establish here. So yeah, I think that's pretty safe, but it's definitely something I'll keep in mind.
I would encourage others to, if you've got questions or want to come off mute and share anything that you're hearing, we would really appreciate that. Not seeing any questions in the chat, Ben. I mean, we've alluded to it, and I think we've probably said it, but you've been doing a lot of speaking engagements on this, talking with individual boards, but also on webinars and on different panels. What other things are you hearing from the sector, knowing that you're talking to kind of diverse audiences in all of these different engagements?
Yeah, I think, as I mentioned a little earlier, the big question a lot of organizations have is, are we doing anything wrong right now? Is anything that this decision said, do we need to change anything in our operations in order to be compliant with the law going forward? And I think for many of them, the idea that the answer we're giving is that largely no, unless you are unless you're really subject to Title VI across the board for reasons that go beyond what the typical foundation is going to find itself in. That there was, the direct impact, like I said before, is limited in the immediate term, but understanding the risks. I've had some people ask about, HR and DEI initiatives, and while I always say I'm not an employment lawyer, that's not something I deal with on a regular basis. The conversations I've had with people who do practice in that area, and what I've read on it is really that, there already were pretty strict laws around what you can and can't consider in employment decisions around race or other protected characteristics, and the decision didn't change that at all. But I was actually on a webinar yesterday with an employment lawyer at a large firm who had spoken with a lot of foundations around their DEI initiatives as an employer, a lot of other organizations too. And her sense was that before this decision, there were definitely some organizations out there who were probably using race or other characteristics in a way that they weren't technically allowed to even before the ruling. So it's not that this changed anything. It was already probably on the borderline, at least in some cases. But her main takeaway for a lot of organizations now is be very careful about how you talk about race or other protected characteristics in HR decisions, or even within the workplace, and how you talk about race, because if concerns about like a hostile work environment, being raised by somebody who feels like that discussion is creating one. And her takeaway was, it's more that this decision in the Students for Fair Admissions cases has brought the whole issue under just heightened scrutiny. So while the law around employment hasn't changed, in this case didn't directly impact it, it's definitely renewing a focus on things like that. We've seen a couple of major law firms already be sued by the same group that sued the Fearless Fund defendants, and they were alleging that their summer associate fellowship positions programs that were aimed at enhancing diversity in the legal profession, that those were discriminatory in violation of Title VII. And as far as I know, the firms that have been sued so far actually went ahead and they just changed their policies for those programs and opened them up more widely. So at least in these cases, and these are, major law firms who obviously are not necessarily afraid of getting sued. They don't lack the resources to handle that. But they looked at this and concluded, hey, it would be better for us just to change this than to go forward and be sued by this group. So take from that what you will. But I do think that there's always been a need to be careful around employment issues. And this doesn't change that, but it invites a good opportunity to let's review everything that we are doing internally with respect to DEI and ensure that it's compliant with what the law already said, which is really to say there's nothing in the law now that says you can't have as a goal as an organization a commitment to an inclusive work environment, that you can't want to ensure access to people of all backgrounds to be hired and to thrive at your workplace. It really just comes down to, can you make any distinctions on the basis of race or other protected characteristics when you are evaluating people or making hiring decisions, and just to be very careful about avoiding the appearance that you are actually in meeting those DEI goals using race or other factors in a way that you're prohibited from doing.
Do we have any questions or any? I know I'm going to keep asking because I feel like I said, I get to talk to Ben about this daily, but I know many of you do not, and so I want to make sure we're answering your questions and what's on your mind right now.
I have a question.
Yes.
Do we think that this is going to spread to things like our women's fund, where we're providing scholarships, raising money for women to go back to school or to go to for a four-year college?
So it's a very good question. I think, and maybe this is hopefully reassuring news to you, Virginia, for anybody else wondering about this, at least under the potential Section 1981 claim, that statute deals with discrimination on the basis of race or ethnicity. It doesn't get into these other areas where, for example, Title VII I was just discussing deals with sex, religion, other characteristics as well, but that's in the employment context. So in this statute that involves contracts, between private parties, the potential cases that might come from that statute is specifically looking at race. So there's not, and the same would go under Title VI, that prohibits discrimination on the basis of race, color, and national origin in the programs or activities receiving federal financial assistance. So it also doesn't implicate, issues where sex or gender is the criterion. So for the time being, at least, they seem to be safe. I've had people ask me too around things like veteran status or other areas where grants are made to individuals or to groups based on these sort of classifications. And similarly, I think the answer there is the statutes that have been used in these early cases here, they really don't get to some of these other characteristics. And in the case, especially of some of these other veterans and some other issues, there's really not been any, I don't think there's just a lot of political will to, they're not the same hot button issue. I think, there's not the same drive by organized groups to say, hey, we don't want veterans groups, for example, to be able to get funding. So I think there's definitely the social and political climate that feeds into some of the issues and areas that are being targeted as well.
Okay, thank you.
Anyone else? Well, knowing that this is a really, as we've been saying, a fluid situation, Ben, and that, it does feel like there's a development, weekly, if not sometimes a couple every week. I know that I wanted to say like we will be providing resources, but where can, everyone find kind of updates about just kind of what's been happening? Yeah, so they can stay informed.
Yeah, well, I think, like you said, we're going to certainly, we're following this closely. So we'll be monitoring and providing updates as things that develop that affect the sector. I think looking at, if you follow legal news at all, like any of the legal reporting outlets, they tend to have good updates on, like SCOTUS blog is one that, provides frequent news, but also analysis on some decisions. And so I think any of those, sort of really focused kind of, I don't want to say nerdy because I guess that's the world that Jen and I live in. And I'm not trying to like put us in that category necessarily, but there are a lot of really, focused, legal esoterica, I would say, organizations and outlets that focus on these issues too. So there's a lot of good reporting out there that helps people stay up to date about what the larger landscape within the the U.S. federal judiciary, which obviously is widespread. And I'll take this moment to highlight that as things stand, as they work their way through courts at different levels and in different jurisdictions, decisions that are made by those courts in those cases apply within the district or circuit wherever we are, that the cases are made, but they don't have the same impact nationally. So we are in a situation where for a while it's very likely, I think, that you'll have different decisions in similar situations in different circuits that they come to different conclusions on the permissibility of some of these. So there's going to be, we're living in a world where some of this will be uncertain for a while until the Supreme Court takes up some of these cases.
So there's a question in the chat from, I'm sorry, my chat box is not good enough, from Chattahoochee Valley. Is there any pushback from colleges or universities expected in receiving scholarships?
So is the question that if you have a scholarship that you administer that has racial characteristics in the decision making, that colleges and universities might say we can't accept this for this student?
Yeah, so if they're, we are not considered public actors because of not receiving federal funding, either pushback from the colleges and universities confirming because they are public actors that none of those things took place, or frankly, high schools being willing to market any scholarships because they too are public actors. So do you see any of that coming, down the road?
It wouldn't surprise me if there were some who said, we are worried about the impact of us. I mean, if it's purely just a student received a scholarship and you're depositing and sending a check to the financial aid office for that student's benefit, you know, I don't think, to me, there's no real issue there with them accepting this money from a private source. The decision was already made independent of them. They didn't use that. It wasn't a scholarship they awarded. I have seen some evidence, certainly in states where legislation has been passed that places restrictions on state instrumentalities like universities or other agencies from accepting funding that has certain DEI type language in it. I've heard of some grantors having to go back. They've had their grantees basically say, we would love to accept this grant, but we can't because of our new state law says that we can't accept it with these terms in it, and getting them to go back and revise their grant agreement to remove the language that would otherwise essentially prohibit the agency from being able to receive the funding. So it's definitely something. It would not surprise me if there are some universities that raise that issue depending on how the program is communicated with them. And certainly I think at schools too, if you're asking local schools to help promote scholarships where race is a factor, it would not surprise me if some of them say, hey, can we even get involved in this? But I haven't heard a lot of that yet.
This isn't the exact same thing, but we do know that there's a university, I think Western Kentucky, that was the lawsuit was filed against them because of some of their scholarship program. And there may be others too, but so we're starting to see tangents of this prickle up more and more.
Yeah, scholarship programs at universities, I do think, given the ruling, I mean, there were some immediate conclusions drawn that ruling by itself meant they couldn't have these race-conscious scholarships. For example, I think Missouri's Attorney General basically said like the next day or very soon thereafter, well, this now means we can't have any race-based scholarships in our university system at all. When in fact, it didn't specifically say that. He was reaching that conclusion based on what he believed the outcome eventually would be. And I do think that given the applicability of Title VI to all these universities, or the 14th Amendment to state universities, I do think that is something that when challenged successfully, I won't at all be surprised by the outcome being that these universities can't themselves administer scholarships that consider race, but that wouldn't or shouldn't in the immediate aftermath extend to private institutions like foundations that are using private sourced money to award scholarships.
It's kind of in our last few minutes here, Ben, unless somebody else has a question that they want to ask, I'd love to hear, where do you think things go from here? And yeah, what are you seeing coming?
I think, we're already starting to see it. I think it's not a surprise that these cases have been filed. I think what was surprising was how quickly, I mean, the ink was barely dry on the Supreme Court's decision in the Students for Fair Admissions case when some of these other challenges came out. The Fearless Fund case was early August, so barely a month following the decision. Same with the challenges that same group had against law firms. So it's happening quickly, and it just goes to show there is and has been for a while a very well organized activist movement that has been for many years and even decades targeting the use of race in some way in making decisions that impact American society. And I think for the near future we will continue to see lawsuits filed against organizations that are expressing an open commitment to advancing racial equity or DEI principles. I think we're going to see, depending on the jurisdiction those are filed in and the way those lean, I think you'll see some pretty disparate outcomes, unfortunately, which leads obviously to confusion. People there's not clarity on how can we proceed if one circuit says you can do this and one says in a very similar situation you can't do it. And that's ultimately where the Supreme Court has to come in and give us a decision.
We've got one additional question in the chat. I'll give you a chance to read it, but I'll read it for everyone else as well. From April, who says that we have a new scholarship fund that was received through a bequest specifically for African-American men and women per the donor's instructions. The only other eligibility is to be a high school senior from the foundation service area and demonstrate capacity to be successful in higher education. Our foundation does not receive any federal funding, only private money. Can we still award this based on the eligibility?
So I think right now the answer is you can, understanding, of course, the risk of any foundation that administers a scholarship that's limited specifically based on race, I think has to anticipate at least the potential that somebody might see this and say, hey, I think I have a claim to make here that this is discriminatory on the basis of race. Because you don't receive any federal funding, really, we're not worried about Title VI applying. This would truly have to be, I think, a Section 1981 claim, and somebody would have to come and say, this is a contract. So looking at the terms and conditions of that and removing any requirements on the recipient that you can to make that look less like there's a contract, that they're not agreeing, there's no consideration. Essentially, that's that bargain for exchange that's necessary to show that there is a contract that exists. So if the other party isn't promising, in return for this scholarship, they're not giving up something. They're not. There's no bargain for exchange, and that would really be the key there to potentially protect yourself from a Section 1981 claim. It doesn't mean somebody can't file one, but it would hopefully give you a better defense when you're, if that were to come to pass. So I think understand the risk, know what the risks are for having a fund like that, and for just being out there. I think unfortunately that's the way that things are going, is that the more visible programs like this are, the more susceptible organizations who run them are to a lawsuit.
On that note, I realize I didn't do this at the beginning. I see one of our colleagues, Rachel, on the webinar, and I want to give her a shout out. She joined the legal resources team in May, I believe. So if you haven't had a chance to meet her yet, I hope you do in the coming weeks and months. Ben, thank you so much for your time and all you are doing. I know you and Rachel and their colleague Rami, and our colleague, I guess, Rami, are putting a lot of effort into this and trying to answer people's questions and put out resources as we get them. So please, email our legal inbox if you do have a question. We want to hear what's going on, or if there are things on your mind where we can be helpful, please let us know. And with that, thank you all for spending some time with us today. I hope you guys are having a wonderful start to November and all the end of year stuff that probably is getting kicked off, if not already in process. I get to share that the goal is to have these quarterly virtual roundtables in 2024. And so if you have any discussion topics or things for the council and CEONet to consider for next year, please reach out to Christy and Melissa and the team. In the meantime, we invite you to keep the conversation going on the Philanthropy Exchange, and the link should be in the chat. And let us know. Like I said, we want to be engaged and be helpful as we can. And so let us know what you're hearing and thinking. And the council's resource page that Jess shared earlier, we'll continue to update that as there are new resources to share or developments. So thank you all, and have a wonderful rest of I think it is Thursday. I have said happy Friday for a couple days now and been corrected. So I think it is Thursday. Have a wonderful rest of your Thursday.
Thanks, everyone.
Thank you.